for the mediation, one of the things you want to do is you want to make sure that the case is appropriate for mediation. So for example, if you have a situation where there's domestic violence and you haven't screened for it and people are coming to you, they say I want a divorce or I want marriage counseling, and you've got such an imbalance of power that you don't, if you in your judgment feel that you couldn't mediate this, and there are times that happens, then it's much better to not take the case on, rather than take it on, get involved, and not be able to help. It's a really, really, really big problem. What are the items of the case being appropriate? Self-determination, ability to enforce agreement, and shared intentions. Okay? Self-determination. So do the people feel, does each person feel like they're there of their own volition? They want to be in mediation. They may not know what they want, they might not know what their bad thing is, but are they both interested, however begrudgingly, to show up in mediation? Ability to enforce agreement, and this has to do with power differential. Okay, so in mediation, right, so if you're going to do all this work, at some point they're going to decide that they're going to have an agreement, whether it's written, whether it's oral, but there's something that they're going to have some kind of a contract that's going to say, I won't do this, and you won't do that, or I will do this, and you will do this. Right? Makes sense. Well, that can only be really enforced if the two parties have some sort of reasonable power sharing in their relationship, like business partners, or like a couple who's married, or like neighbors who have equal footing, etc. If you have a power imbalance, whether it's boss-employee, or abuser-abusee, or sometimes parent-child, but when you have this disparity of power, then it's a problem for the mediator in terms of protecting the process, because if the parties agree and the lower power party can't enforce the agreement, then what's the agreement worth? Shared intentions. Okay. So this is when the assumption is that both parties want to have an agreement, that they're there for the same purpose, as opposed to one party is there, and this often happens in commercial cases. One party is there because they want to settle, and the other party is there because they want to have discovery. And then the other question is, are the parties ready to mediate? So what's the legal context? And sometimes, in fact often in community cases, people ask, one of the things you ask as a mediator is this matter pending in court? So you want to understand what the legal context is. Certainly if you're getting a court-referred roster that's pending in court, what's the emotional context? I mean, are the parties, are they able to carry on with the mediation? Does something happen that's really raw where it's not appropriate? And then make sure that there are parallel sort of processes going on. So are the parties, while they're in mediation, are they also suing each other? And what does that mean? Or maybe while they're negotiating the will, someone's trying to contest the will and someone's trying to get some paperwork to dirty up stuff like that. So is there something going on in the ether that can interfere with the mediation?